This is BC. So get ready to ask your question, any legal question related to immigration and naturalization, or anything related to family law, corporate or civil matters. The number in the studio, 972-235-5555. Yes, this is the time when you can call and get your answers right away. And for appointments, once again, 972-361-0606. Their website, aluvalialaw.com, or you can also log on to yourdesilawyer.com. And with that, would like to welcome Pallavi on air. Good morning to you, Pallavi. Tell me, how are you doing?
A wonderful morning to you, Meetu. Glad to be with you today and hosting Your Business Matters. We're here every Wednesday at 10:30 and hope to interact with the community and to be able to answer all their questions pertaining to any aspects of the law. By default, I think we have more immigrants here, so we get a lot of immigration questions. You're welcome to ask other questions as well, and we hope to answer them. Me too, before I start taking calls in the air, just wanted to give an update, and I know we've kept the community in touch with what's going on in the H-1B world and
Correct.
how brief that quota is and how what a short time that it runs for. And at this point, wanted to say that USCIS has finished the adjudications in terms of the receipting of the paper of the applications, the administrative input into their systems, and all receipt notices as of right now have been issued. So this is the time where people will either see their applications returned back to the petitioners, which are the employers, or that they would get a receipt notice. For employers that still have not seen their receipts come in, just go ahead and just check into your accounts, bank accounts, and see if the checks from the USCIS have been cleared. At the back of the check, you should have the receipt number, and that should give you an indication, of course, that your application did get receipted just by the mere cashing of your checks. The other little update that I wanted to provide was for the roving employees of H-1B employers, it is now a requirement to amend your H-1B anytime that your employee changes projects and moves to another city or state with another project with another end client. That is now become a requirement. It is just not something that is suggested, recommended by your attorneys. It is now required by USCIS, and USCIS can go back into your applications and revoke the beneficiaries that were not timely filed. And so the expectation of the government is a little clear right now, but what is a little unexpected is their stance of applying this to the older cases as well. So if you're an employer or you're an employee, please be vigilant and make sure that if you're working for end clients, that your application has been amended already.
Thank you so much, Pallavi, and our entire community and me myself, actually, we really appreciate your update before you start taking calls. Should we do that?
Yes, let's go ahead, please.
All right, let's do that. Going to our first caller, Fun Asia Radio. You're live on the air. Go ahead and ask your question, please.
Hi, my name is Megha. I have a question regarding H4 EAD. So, hello?
Go ahead.
Yes, go ahead, please.
Yes. Yes, so I'm planning to apply for H4 EAD this May 26, and I just had a question that if my husband moves his company, like he moves to some other job, and the present employer actually withdraws I-140, and then it is filed again in the next company, then will my H4 EAD be invalid in that duration when one company withdraws the I-140 and the other company files it? So there will be like a break of 1 year or so?
As long as you have an approval notice for the required length of time, and that length of time will be the time that your husband has been given his H-1B, while the case is still being revoked, but it has a placeholder of that I-140, do not expect the government to come back and start revoking the EADs that are given to the H-4s. That is not going to happen. You can assume that as long as there is another peg holder that gets put in place. Now, the more conservative opinion on this one would be just make sure that before your spouse were to move from this employer, you have another employer that is filed a perm, gotten that approved, because that's the fairly lengthy process. And when we're going to the I-140 that may still get adjudicated within a few weeks, given that it accepts premium processing. Now, so my opinion on this one would be, I do not think that the government is going to be set up for going back and revoking the H-4 EADs when there is a withdrawal of the underlying I-140. But my advice to everyone is just make sure that those ducks are in a row and that you have your next employer covering you as promptly as possible to prevent any issues from happening.
Okay, and so just to understand, till the time that placeholder, that priority date is there,
yeah, do not think they have the ability, and they have not addressed that in the change. They have not addressed that. But once you've used that approved I-140, then that approval is not being taken back from you because they don't have the ability to go back and revoke these EADs. So in that particular aspect, though not addressed, the better approach would be to just have another I-140 that covers you while you move on.
Okay, got it. Yes.
All right, thank you. Thank you so much for your call and all the best to you. Moving on to our next caller. Once again, the number in the studio, 972-235-5555. All right, you're on the air. Go ahead and ask your question, please.
Hey, Pallavi. Hi. I have a question. I'm on H-1B here in America. And I came to America in May 2012. And my question is, when I left my previous company in India, I resigned there in April 2012, but because of their policy, they said I have to serve 3 months notice, and I said, no, I cannot. I got to join a company in America, and I left. I got my relieving on 7th May. They relieved me, but the thing is that they gave me the letter until July 2012. Now my company is filing my perm, and they requested me the start and end date of all companies in India I worked in past. So what dates should I give? And will this have a problem that I left that company in May 7th? Though I have an official mail, but the experience letter is up to July 2012.
Okay, so if the experience letter is there, you're free to be able to use that experience. However, if you feel you never worked till then, but you only worked up until the time you came to the US, then you could flush the dates you could keep them together with what's coming up for you for the US employment to have no break in employment if you're requiring that time, right? So if it is that you started here, working here on the 21st of May, and you had continued to work right up until the time that you had come, then you can put those dates. Now, if you stopped to work and you discontinued work on the 7th of May, but you have a letter that goes over, I don't think it would be held against you. So you can just say that though you got an experience letter for this time, you had actually started it at that point, and that's not going to be a problem. Are you going to be looking for that employer support to qualify you for the perm under the category which you're going?
No, I'm not sure.
So that's just part of your information on your resume that you're trying to authenticate. So yes, I mean, if you started work and you entered the country and that is shown on your passport, and you started work for this employer and you had given up work there, then you can put in the valid date that you had ended your employment with the previous employer on the H1 in India before you joined this H-1B.
So should I mention them in a comment that yes, I have an experience letter until July, or I should ignore it?
Yeah, well, you could just put, if you're putting out a perm questionnaire for an attorney, then just say that my experience letter goes beyond the last date where I worked there, and the attorney should be able to cover it.
Okay, thank you. Thanks, I appreciate it.
All the best.
Thanks, have a good day.
All right, thank you so much. Going to our next caller, and yes, do want to mention for all the listeners, this is Pallavi Ahluwalia from Ahluwalia Law Offices, and their law firm is located in the Dallas-Fort Worth area, and their practice area include employment-based and family-based immigration matters, including naturalization and citizenship, family law, and corporate and civil matters. And with that, we will take our next caller on the air. Go ahead and ask your question, please.
Hey, I have a question. I want to know whether is there a proposal for I-140 portability under Obama's executive order? came in last November.
Portability, to be able to file a 485. So portability, if you're looking at using that I-140 and then moving to another employer, right? Similar to the AC-21 portability that is well known. Is that the question?
Right. Yeah. So if I have an I-140 approved from my employer, and can I and if I'm moving to a new employer too, so I heard that there is a portion that you don't have to file an I-140 again.
Yeah, no, that was his announcement, and it was actually going to be announced this week. But for some politics, I believe that had prevented that announcement from coming out from the White House. Given that announcement, there will be an ability for people to be able to either register the I-140 and get the benefits of the 485, or allow the full-scale 485 filing, where the I-140 will then become portable. At this point, though it is an announcement, there is no process that's been announced. And again, I know that this was an expected announcement for this past Monday, and it did not come out. And so just stay closely tuned to what is going on in terms of the immigration updates, and we just bring them here to you as well. And if that is the update and the portability is allowed, then we will announce it. But that would be herald a big change, because that would also mean that a lot of people will get the EAD AP benefits and be able to file their 485s without the priority date becoming current.
Okay. Thank you.
All right. All the best.
All right, 972-235-5555, number in the studio. Going to our next caller, Phanisha Radio, you're live on the air. Go ahead and ask your question, please.
Hello?
Yes, go ahead and ask your question.
Hello?
Can you hear us?
Go ahead, please.
Yeah, hi Pallavi. I'm on 485 pending. Actually, my wife is not included at the time. So she's here on visitor visa right now. Can I include her in my 485?
Yeah, the only way would be, so you are the beneficiary of an employment-based 485?
I'm sorry?
Are you the beneficiary of an employment-based pending 485?
Yep.
Okay.
Yeah, employment-based.
So at this point, unfortunately, your wife cannot be included until your priority date is current. Is your priority date current by the visa bulletin?
No, actually my priority date is 2004. I'm on EB3 2004 December, so it's 1 year ahead.
Okay, yeah, I see that India is currently processing January 15th of 2004. And so the wife will have to return back unless she has other options to stay that are non-immigrant options, but she cannot file a 485 till the priority date is current.
Oh, she's on visitor visa right now, so she has to go back and come in again like that?
Yeah, I mean, that may be her only option, or if she has any other student options or any other options that she wants to stay here for, then that's something that she can do. But and even with the visitor visa, that's a word of caution that I give everyone, is just be careful. It should not be where she's staying here 6 months and she goes out for a month and tries to re-enter for 6 months. Because if they see that she's staying here longer, then she's going to have trouble with it, and they will just kind of cancel the visitor visa out. So you have to carefully use it, meaning that when she comes in, she can stay here for 6 months, and if she extends it once, then she goes and stays out for 7-8 months and then returns back into the country.
Okay, she stays 6 months, she go back and she can come back like after 2-3 months like that?
No, do not advise that. That's what I just said. Please don't have her do that, because if they discover that she's staying here longer than she's staying abroad, so basically she's a citizen of India and she's staying here longer, then they consider her wanting to be a resident here, and that will cause them to deny her entry and cancel her visa. So do not take that chance right now.
Okay, so she needs to stay a long time in India.
Correct. She needs to stay, whenever she goes out, that she stays 5 months, 6 months, even longer if she can abroad, and then she comes back in for 6 months.
Oh, okay. So she can be included with my 485?
Not currently. Not till your priority date is current.
Oh, okay. Thank you, ma'am.
Thank you so much. For appointments, you can call the front desk manager at 972-361-0606. Going to our next caller, Fanisha Radio, you're live on the air. Go ahead and ask your question.
Yeah, hello, hi. Just I wanted to know, if the employer revokes the H1, how long we can stay?
No, there is, so the moment there is a revocation of the H-1B, it puts the person out of status, immediately out of status. So as soon as the person, there is no grace period that is given. The person has to leave the country almost immediately. There is no option from a revocation or a denied H-1B to even change status to another status, because at that point you've lost your underlying H-1B status.
Okay. Though we have approved I-140 with that?
That would not matter till you have another employer that is using that I-140 to get you 3 years on an H-1B, and that will also have to be done through the consular processing mode, which means the approval notice happens here, but you have to go consular processing and then re-enter the country.
Okay. And if we came on H4, can we travel to India, or do we need a stamping if we are on H4? Like if there is a new rule, right, we can also work, right? Like if someone is on H4, even they can work.
So if somebody has a valid H4, so if this is related to the same person who's been revoked, then for the person to assume an H4, they have to either go stamping or they have to file for a change of status. A change of status can only be filed while you maintain valid status in the country. That's number one. For the H4, yes, the person can file for a change of status to an H4 or obtain consular processing and then come back and file for the EAD.
Okay. All right. Thank you.
All the best.
All the best to you.
Thank you so
Going
much.
to our next caller, Fanisha Radio. You are live on the air. Go ahead and ask your question.
Hi, thank you, Pallavi, for doing this for us. I actually don't have a question. I was just wondering if you'd be kind enough to just repeat your update that you did before you started the questions. I joined in at the tail end of the update.
Okay, so we were talking, we spoke about three things. Number one was that the USCIS has finished out the receipts and the administrative processing of the applications and just the process relating to the current H-1Bs that were filed in the quota. The second update that I had was relating to amendments and the fact that if you are a roving employee, which means that you work for end clients, USCIS now requires all employers to file for amendments on the I-129, which means that you have to file an H-1B rather than just doing the LCA, and the requirement is that it must be filed prior to the beneficiary joining the project or immediately as joining the project. My third update was that the government does have the ability to go back and look at the cases that were not amended and go back and now revoke them for not having been done. So it's something that is a new announcement, but it is where the government has the ability to go back and check on the employees that were not amended when they moved their project. So my advice to everybody is go ahead, please have the employers or the petitioners quickly file for amendments if you've changed projects and you have your H-1B approval that happened with the older project.
Okay, so this was just related to H-1B approvals. Because the thing is, my husband, we have an EAD in hand. We are 45 pending status right now. And my husband worked for BlackBerry, and they shut down, and then he joined a smaller company that is not I don't think they are an employer, but we were thinking of doing the AC-21 portability. We didn't do it at the time because
yeah, it must be done. You have to protect it either by AC-21 filing, or you have to get the H-1B transferred. So both are options, but if he has a 485 pending for over 6 months, he has an I-140 that is approved, then he is portable.
he's good.
No, he is portable, but he must file that with the government.
Okay, no, so the thing was, with the smaller company, we didn't file it, and now he's changing a job again and joining a huge MNC, and they want to go ahead and file it. So my concern was we did not do it with the smaller company, so is that going to be a problem?
No, as moved and he's got his position details for what he was doing with them, and it was not more than 50% different. It was actually closer to what the perm was filed for with BlackBerry. I think you should be okay. So you don't have to now file for the small company. You can just go ahead and file for the third company now.
All right. Okay. All right. Thank you so much.
All the best.
Thank you so much. And Pallavi, we have 2 minutes to go. We'll take a quick last question maybe. All right.
Let's do a quick another call. Let's take one more call.
Yes, let's do that. Going to our next caller, Fun Asia Radio. You're live on the air. Go ahead and ask your question.
Hello.
Yeah.
Hello, Pallavi. This is Sumedha. Thank you so much for doing this. I am thinking of applying for my H4 EAD towards the end of this month. Now, my question is it okay for me to travel to India in July and August while that application is being processed?
Yeah, so while as long as you file for the application, you will have to go through fingerprinting too. Just make sure all the formalities are done. You have to be on H-1B status. So while you're in status, you filed it. While it's pending, you travel, but you return back. It will be okay. I do not see anything that prevents you from doing that currently. Just make sure all the formalities relating to the fingerprinting that deals with the EAD is resolved prior to your travel.
Okay, and also I would need to stamp my H4 before I come back. It's not stamped currently, so none of these should.
But you have current status, correct? On H4?
Yeah, my husband has H-1B, and his is current. I mean, his I-140 is approved.
Yeah, no. My question to you is, you are maintaining H4, not on the H-1B.
Yes.
Correct?
No, I'm on H4.
Okay, yeah. So you can use that approval notice to file. And then when you return back, you're returning back with the H4 stamp anyway, so you're maintaining your H4 status when you enter the country.
Right. And so traveling should not
should not reset it. Currently, that's not known as an issue.
Okay. Thank you so much, Pallavi.
All right. Thank you so much. And that marks the end. And let me tell all my callers who are trying to reach Pallavi right now, Pallavi will be back next Wednesday, same time. And thank you so much, Pallavi, for doing it every Wednesday. Thank you so much.